Welcome to Financial Insider Weekly. I am your host, Michael Gray, CPA. My guest today is Professor Patricia Cain from Santa Clara University. She's a professor of law and has been teaching law for over 35 years. She briefly practiced law before she became a professor, and she's been a member of the Texas and Iowa Bar, and provides consulting services to law firms. Patricia is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. And also, you've contributed to some books there as well, correct? Yeah. So today, Patricia and I are going to be talking about income tax problems of same-sex couples. And I want to point out before we get started a couple of things. First of all, many of these problems are shared by unmarried couples, and so we'll try to sort of highlight maybe a little bit of those differences. And the other is we are dealing with very complex issues in the tax laws. So you should view this as a starting point for a bigger discussion with a tax advisor or attorney. So we want you to get qualified legal and tax advice. And also, we're mostly addressing issues from federal and California standpoints. So Patricia is teaching at Santa Clara University here in California. I am a California CPA, and so we're very highly involved with community property and so forth. Viewers in other states should seek advice from about their local laws. Okay, so Patricia, thank you so much for being here with me today.
Thank you for asking me, Mike.
Okay, it's a real pleasure, and I'm very excited, by the way, to have you here with me today, because these are such timely topics, and we'll get into some of the timeliness today.
Absolutely.
But I want to get right into our questions. So first of all, start to get into this is, what is the Defense of Marriage Act, which is a federal law, as I understand it?
Right. The Defense of Marriage Act, which is also known as DOMA, was passed by Congress in 1996. It was a kind of backlash to the threat of same-sex marriage going on in a litigated case in the state of Hawaii at that time. Now, no one ever got married in Hawaii. In fact, no one ever got legally married in the United States until 2004. But in 1996, Congress passed DOMA, which says that for federal purposes, for any statute or regulation at the federal level, the federal government will only recognize a marriage between one man and one woman. There's another part to DOMA that has to do with full faith and credit between the states, but for federal tax law, what we're worried about is the federal part of DOMA, so that under the Internal Revenue Code, even if you are married in California, which there are legally married same-sex couples in California, or in any other of the other 5 states that recognize same-sex marriage, you will not be treated as married for federal tax purposes.
Okay. Thank you for that. Okay. So, are there any legal challenges pending for DOMA?
Oh yes, there have been some challenges in the past, none of them successful, but there's a very interesting challenge right now that's being brought by a public advocacy group called Gay and Lesbian Advocates and Defenders. That's GLAD. They're in New England. They have brought suit in federal district court in Massachusetts, claiming that DOMA, the failure of the federal government to recognize same-sex married couples, violates the 14th Amendment of the federal Constitution. Most interestingly, the Commonwealth of Massachusetts has brought its own separate action in the same court, claiming that DOMA, so long as it is on the books, violates the 10th Amendment, which is an amendment in the Constitution that protects states' rights. Massachusetts thinks that if it wants its citizens, same-sex citizens, to be able to marry, the federal government ought to recognize that. So that's a very interesting development about the future of DOMA. In addition, of course, President Barack Obama told us during his campaign that he supported the repeal of the Defense of Marriage Act. He's now in the strange position of having his Justice Department defend the act in the federal court at the same time that he wants Congress to ultimately repeal it.
Okay. Could you remind us what the 14th Amendment is?
The 14th Amendment is, in the federal Constitution, it has an equal protection clause. So it's a violation of the principle of equality guaranteed under the federal Constitution to treat same-sex married couples differently from opposite-sex married couples when they are exactly similarly situated. All of the same state laws, rules about property law apply to them.
Okay, good. Thank you for that. All right. Well, we're in California, as I said. So right now we have this situation where we recently passed Proposition 8. Not so long ago. It feels longer ago in a way, doesn't it? But anyway, it does to me. Anyway, but tell us about the status of the litigation on Proposition 8 and what's going on related to that.
Well, that's the most interesting case on the West Coast. This
Okay.
is the case that's been brought by the very well-known lawyers Ted Olson and David Boies, who, as you may recall, litigated against each other in Bush v. Gore. They have brought suit in federal district court in San Francisco. The trial just started yesterday. We were supposed to have it televised, but they've not allowed it to go on YouTube yet.
Yes.
The Supreme Court's going to decide by tomorrow whether it will release the film to YouTube. So everyone is in the courtroom blogging away, and I've been following it with great attention.
Okay.
This is a case that's challenging Proposition 8 under the federal Constitution, under the 14th Amendment, the same equality principle that DOMA was challenged. And most people thought the DOMA challenge, since it's not really about the right to get married under the federal Constitution, it's about the right to have your marriage recognized by the federal government. That's a smaller issue than whether or not under the federal Constitution, all same-sex couples have a constitutionally protected right to marry the person of their choice. If there was a win in the Perry v. Schwarzenegger case, the Prop 8 case, that would be huge.
Yes, yes. So just to let our viewers know, today is January 12th.
Right.
And so the first hearing date on this case was yesterday, and it's all over the news. So anyway, it's a big deal. All right. Now, also, would you let us know a little bit about recent California legislation recognizing out-of-state marriages for same-sex couples?
Right. The question in California is which same-sex marriages will be recognized. As you know, the California Supreme Court in 2008 issued a ruling that said it was against the principles of equality in the California Constitution for the state to deny the right to marry the person of your choice to same-sex couples. That became effective in June of that year. And so as of June 16th, same-sex couples were able to get married.
Right.
Then there was a rush to put Proposition 8 on the ballot. Proposition 8 did change the California Constitution to read that only marriages between a man and a woman are valid or recognized in California. That left open a question when the subsequent challenge went to the California Supreme Court again. There were 18,000 couples who did get married in California before Prop 8 went into effect. The California Supreme Court has ruled that those marriages are valid, that you cannot retroactively, through a ballot measure, take that right away. So an interesting question then arose about, well, what about people who had gotten married in Massachusetts before Prop 8 was passed? Or in Canada, or in some other jurisdiction where it was recognized. Since their marriage was legal during the time period that such marriages were recognized in California, shouldn't their marriages be recognized as well? That issue was not addressed by the California Supreme Court, so the legislature stepped in and clarified it. And they clarified it, I think, totally in keeping with the spirit of the decision by the California Supreme Court. They said if the marriage was legal in another state or jurisdiction prior to the effective date of Prop 8, and that couple is now residing in California, the state of California will recognize those foreign marriages.
Great.